Hello, everyone. Welcome. I'm Therese Bacon, Financial Education Specialist and lead of the Seminar Series program. We're so glad that you could join us this evening. These sessions are designed to give you practical, relatable financial education that helps you feel more confident in navigating your money. We have a wide range of presentations planned throughout the year. You can explore upcoming topics and register by visiting msufcu.org/events. Today's event is also being recorded, and you're able to rewatch or share this session by visiting youtube.com/MSUFCU and then selecting the seminar series playlist from there. So we're very excited this evening to have Laura Cantu, Deposit Operations Manager, here to walk us through today's topic, navigating estate accounts. Managing financial matters after the loss of a loved one can feel very overwhelming, especially when you're not sure what steps to take or what documentation might be needed. So tonight's session is designed to help make that process a little easier to understand. Laura will walk us through estate account basics, documentation requirements, and what happens to accounts after the member passes away, and then share some other helpful resources available to you.
Perfect. Okay. So our agenda this evening, first I would like to share a little bit of a disclaimer. The topics featured in this presentation include information that should not be considered legal advice. All financial institutions and situations are different, and further research may be needed on this particular topic. So just want to start by saying that. So this evening, what we are going to do is cover some key concepts of how estate accounts work here at MSU-FCU. We will talk about how an estate account is opened and what that process looks like. We will talk about account management, so what happens after the account is opened. And finally, some additional resources that can help you navigate the process. Okay, so let's start with the basics. So what is a probate estate? So an estate is established after an individual dies. So whenever a person passes away in a specific county and their family determines that an estate is required, the family member or a friend or whomever it is that would like to represent that particular estate would contact the probate court in the county in which the individual died. So this is a little bit different than where the individual may live. It does depend on where they passed away. So when we think about an estate really is only assets that are in the deceased individual's name alone. So if someone has a joint account with their spouse, those assets are not part of an estate. Those assets would be owned by the surviving spouse. So anything that is just in the decedent's name would be considered to be part of the estate assets. So as I mentioned, joint accounts are not part of a probate estate, nor are trust assets. Those are owned separately by the trust. So when an estate is being established, a probate court will look at several things. One, they will look at the assets that are owned by the decedent. They'll also look at the debts that are owed by the decedent, and they'll look at any property that is owned by the decedent. And that is what kind of comes together to assess whether or not a formal or an informal estate would be required. And the probate court would provide the guidance on which direction a family would be going. So many times we are presented with information about a will. So a family member will call us and say, my parent or my spouse or whomever has died and they have a will. So can I please provide that will to be able to access the account? So unfortunately for MSU-FCU, a will is not something that we are able to utilize for the continuation of establishing who gets the funds or how that works. What we really would need is a copy of a death certificate. The death certificate is the legal proof of death that the credit union recognizes in order for us to take any action on an account. So the will, though, plays a very important role. So in a probate estate, if a will exists, then the court would review it to determine what the decedent's last wishes were as it relates to their assets. So they may say, I leave everything to my spouse, or I leave everything to my spouse and my children. And so the will really helps the probate court to understand to whom the funds and the property are to be distributed. Unfortunately, we do see many instances where a will is not present. So the individual either didn't have one or they didn't want one. And so in that particular case, Michigan law will decide who receives the money and the property. And so it's a little bit complicated, so I won't go into any major details. But in that case, a personal representative typically would be appointed, and they would be able to work through the process of distributing assets, or they would be able to work through the process of paying debts. Oh, I also wanted to point out that navigating through an estate process is not a fast experience. So, from personal experience and from working with these types of accounts for the last 10 years, we have recognized that it takes between 6 months to as long as sometimes 2 years for an estate to be finalized, depending on the complexity and what is included in an estate. So, sharing with your family members, these are where I have all of my assets. This is how I have all of my accounts titled. This is where my money is extremely important to do before it's too late. Without providing any of that detail, it can take a lot of time just to sort of sort through where everything is, how it was, what the ownership was. And so having that information shared with a family member or a loved one can really take a lot of the stress out of those after death steps. Okay, so the letters of authority. So when a probate court is presented with an application to apply for a probate estate on behalf of a decedent, the family member or friend will basically ask permission to represent the estate. And so legally, they and the estate and the person are the same thing. So if I have the authority over my dead parent's estate, then basically legally I am that person in the eyes of anyone who is working with me. So, if approved, the court would then issue these letters of authority. Now, I'm showing you this is just for Michigan. Each state is a little bit different. Some of the states, in fact, use different terminology in the way that they title the wording of the letters. So, in some states, the titling is called letters of testamentary or letters of office. But in Michigan, they call them letters of authority. And so the probate court will submit a formal copy to the personal representative. It gives a file number. It says the county in which the probate court is located. It tells basically anyone who may need to know this information, I am now the legal representative. It gives an expiration date of how long the estate is established for and how long the letters are valid. Once the letters are no longer valid, MSUFCU does require the reissuance of the letters with an updated date on it in order for an account to be continued to be used. So in the outline of how all of our accounts work and our membership and account agreement, it does give that particular information in writing. So it's a little bit helpful to have that for reference. Okay, so we're backing up just a little bit here. So when we are notified of a member's passing, we are notified in a lot of different ways. So typically a family member or a spouse or a child will reach out to us and inform us that one of our members has passed away. So we can receive those notifications, as I said, in a number of ways. We can receive those over the phone. We receive letters in the mail regularly, sometimes from the family member directly, or maybe from an attorney who is representing the estate of that particular individual. We have a secure messaging portal called eMessage that you can access through computer line or the mobile app. And we can receive copies of a death certificate that are securely attached to one of our messages. We receive notifications in our branches, and we also receive them via fax. So there's a number of different ways that we can receive that notification. Upon notification, it really depends on the relationship of the notifier to the account. So we may not be able to share account details unless the person contacting us is a joint party on the account. So if the person who's contacting us is, for example, a power of attorney for that individual, the power of attorney does cease at the time of the member's passing. So we will not be able to disclose any further information at that point in time. Or we can also disclose information to a personal representative. But barring that, we can't really share specific account details. We can still, however, explain generally how next steps work, and then we will take immediate action to protect the account. So if it's just a personal account, doesn't have a beneficiary or anybody else on it, or a joint party, we do lock down the account in order to protect the assets from somehow being used. Unfortunately, sometimes what we see is funds are taken. So a family member might find an ATM card or a credit card. And this isn't typical, but we have seen funds being utilized through those channels until we are notified. So we, again, one of our main priorities, besides sharing our condolences with the family, is to protect the assets for whomever it is that they are intended. As I mentioned earlier in the presentation, we do require a death certificate before we can act on the account. So what I mean by that is we will obviously protect the account. We will lock it down. We will make sure that access online is removed, access to debit cards and ATM cards are removed. But in order for us to take action to either change ownership or to update the accounts in any significant way, we do need a death certificate so that we can ensure that we have that before proceeding. Okay, after notification. So we get asked a lot of questions. So what now? What do I do? So if it's a joint account, the joint party still has full access to the account. Absolutely nothing in that vein changes. The only thing that would change, however, is if direct deposits were coming in the name of the decedent, we would have to stop those from continuing. So that would typically be Social Security or other pension funds or retirement funds. So the credit union takes action on Social Security deposits that are being made in the decedent's name, and we do automatically place holds on those funds because if there's a couple of different circumstances, and I won't go into too much detail, but if the funds are received after the death of the individual, then they do have to go back to Social Security. And then if the funds are received before the person passes away, the funds typically get to stay. So we can answer specific questions if you have them on your own, on your account, if you give us a call. So once we determine that there is going to be an estate, or once someone goes to a probate court, typically they contact us and say, okay, I am ready to open an estate account. Where do I start? So MSUFCU, as you probably all know, is a membership-based organization. So as a federally chartered credit union, our job is to first and foremost ensure that we are working with members. And so in order to be a member of the credit union, you set up an account, you have a $5 share that you maintain with us, and as a primary member, you have voting rights as a member of the credit union. So an estate operates very similarly. So in order for the estate to qualify, and this is regulation that is provided to us by the NCUA and by the Federal Credit Union Act, in order for the estate to qualify as a member, either the decedent had to have been a member at the time of their death, or all beneficiaries of the estate must open and maintain a membership with the credit union while the estate is open. And I know that that can be kind of confusing. We do recognize that sometimes, as a federally chartered credit union, this requirement is challenging. And so sometimes if the estate has a lot of beneficiaries, or they live all over the country, or they are charities, that may not be a possibility for all of those individuals or charities or companies to be able to have membership with the credit union to be able to establish an estate. So I don't typically say this, but we may not be the right fit for your needs if that is the case and that circumstance exists. So generally speaking, many times our members have accounts with us prior to their death. So establishing an estate account is very simple. But again, we can help you navigate those details if you find yourself in this particular position. Okay, So all of our specialized accounts are set up in the same way. As you can see on the right, we have our estate account application. All of our specialized accounts have a section at the top of the application that says, these are the requirements to open an account with us. So it's spelled out exactly what we need. So it tells you all the documents, it tells you all of the requirements, it tells you all of the things that you would need to bring with you to be prepared to open that particular account. So we need a couple of different pieces of information. Can we go back one? Thank you. So the letters of authority provide us with the personal representative's name. It provides us with the issuance date, when the letters were issued, when they expire, and any court limitations. So sometimes an estate will say there are two people that perhaps want to manage an estate. We need to see that both of those individuals can act independently of each other. That is really important because the way that our systems are set up, it requires every individual to be able to act without the permission of another person. We don't have the ability to monitor a transaction that two people have to approve. So if you give good advice to a family member, if they're in a position to establish an estate, we always want to ask if there's two people that they can both act independently of each other. So with this application, we would need the name of the estate, and that's typically provided by the probate court. So it would say the estate of Laura Cantu, or the estate of John Smith, or whatever the case may be. Another thing that is required for all estates is something called an employer identification number. And that is something that is provided to an individual representing an estate through the IRS. The IRS has a fantastic website that allows you to self-service that particular process. It takes about 5 minutes, and at the end of it, you can download or print a copy of the employer identification number, or EIN, for the estate, and that is a requirement for us to open the account. So once the estate account is established, it works very similarly to basically all of our other types of accounts. So online banking is permitted, debit cards, checking and savings, checks, ACH deposits or withdrawals are all permitted on an estate account. So one of the things that we hear a lot is that individuals that have estates with us are surprised when we inform them that this really isn't supposed to be used for personal use at all. It is truly intended to be used specifically for the purpose of paying final expenses, navigating the end of the estate process, and paying out distributions to heirs, and then finalizing the account. So it's not intended to be a long-term personal account. And we do see a lot of that. So we do recommend that within the time frame that the estate is established, of course, continue to use it. And every year, the probate court will require a personal representative to provide them with a list of all the activity that has been done using the funds in the estate account. This just ensures that the funds are being used specifically for the purpose of the estate, and that they are being used in what we call a fiduciary manner. So as a personal representative, the person who is in that position is basically a legal representative, and they're doing what is in the best interest of the estate, not within their own personal best interest. So the court would not want to see somebody basically who's not a beneficiary of an estate using the money for themselves, or taking that money and utilizing it. It's very similar to the way in which a trustee on a trust works, or a power of attorney agent works. You're doing it for the other person, and you're not doing it for yourself. So estates work very similarly. So the probate court may say, well, actually, they may not say, they will say, we need to see an accounting. And if at the point where the estate's done, there's no more funds, everything's been completed, then they will close the estate out. Okay, So account maintenance. So after the account is used, the only time that you will likely hear from MSUFCU is when the estate documentation is about to expire. So typically about 3 months before that happens, we will send a letter out saying this letter or these letters are going to expire. If you'd like to continue to use the account, we do need to see the letters are either reissued from the probate court or that you've completed everything and that we are going to close the account out at that point in time. We do not monitor how the account is used or review each transaction. So truly, it is up to the personal representative to use the account the way it's intended to be used. Um, and a big question that we get asked a lot is about checks. So if I come into a branch and I have a check made payable to the decedent or to the estate of the decedent, those are checks that need to go into an estate account. So typically following the death of somebody, especially a joint party, may receive a check that's made payable to their spouse or to somebody else on the account that is no longer alive. We are unable to accept those checks. So those checks belong to the estate of that individual and cannot be deposited to a different type of account. So we will say, unfortunately, we're not able to take that, but you can either take this and put this in an estate account, or there are a couple of other options if an estate is not being established. Okay, so we've talked a little bit about this already. So the account can stay open as long as the letters of authority are still valid. So I've already mentioned a little bit about this, but we will contact the personal representative prior to the expiration of the letters. And then if the letters expire, we do freeze the account until the updated letters are provided. It's not intended to be inconvenient for anybody or to be difficult, but because they are legally binding documents, the credit union does want to make sure that we are managing the account based on what the probate court has instructed us to do, which is to keep the account open and available until those letters expire. So we've talked a lot about when estates are necessary. There are many instances when estates are not necessary. And again, my recommendation is to seek tax advice and legal advice on what is best for that decedent's particular situation. So what I'm sharing is just a couple of options that are available based on different scenarios that we see at the credit union. So we hear all the time, they didn't have my family member did not have an estate. So in the state of Michigan, for example, and each state has this, they define legally for their particular state based on many different factors, but typically it's based on the cost of living, that each state has a threshold at which they say this is what is considered a small estate. In Michigan, that amount right now for 2026 is $53,000. So if the decedent individually has less than $53,000 worth of assets or funds that belong solely to them, then an estate is not necessary. So that would be considered a small estate. If the estate is more than $53,000 and there's property or there's other complications, a probate court will decide whether a formal estate is needed or an informal estate is needed. And based on that guidance from the probate court, that would determine which direction a family would need to go. So many times we see individuals that do not have enough funds to constitute the smallest or the formal estate process. But so in that case, we have a couple of options. So one of the things that we work with is a document, and I believe that should be on the next page. Yes. So we work with a document that is called the Affidavit of Decedent Successor for certain assets. And the state of Michigan basically has made it very, very easy for an individual or a family member to utilize this document in lieu of an estate. So as long as the certain requirements have been met, this document, which is a one-page document would be completed and filled out. Is there another image with that, Therese? There we go. Thank you. And we would be able to either close an account using that document, or we would be able to negotiate checks. So, as I mentioned, small estates are going to vary wildly by state. We are now in the state of Illinois. We have opened 10 locations there in the last 2 years. And so we've started really looking into how estates work in Illinois. Now, Illinois has their threshold is $150,000. And that's because the cost of living in the state of Illinois, mostly thanks to Chicago, is quite high. And so $150,000 has been deemed what their limit is. And each state has a little bit of a variety, again, based on cost of living. California, for example, very large, expensive state, has a much higher threshold. So in some cases, a probate court also may do something called a petition or a petition in order for assignment. And what that is if I were to go to a probate court and I say, I don't have an estate for my loved one, but I am the heir. And there's nobody else, it's just me. I didn't have any siblings. My mother's not living. So I am the heir of this person's assets. I would like you to agree with that, and I would like to be paid out assets that are owned by the decedent. So maybe that's in a bank account, maybe that is in some other account that person had just in their name. Maybe there's a vehicle that was owned free and clear by them. And so the court will review that information, and they may ask that person take that document to the financial institution to try and negotiate the funds in that particular account that's held at that institution. So we review all of those different scenarios, and we will work with each scenario individually to assist our members. So as we are kind of nearing the end of our presentation, MSUFCU has recently made a partnership with TrueStage. TrueStage is a company that we work with for a number of different services that we offer to our members. And one of the recent additions to our repertoire of products and services is something called the Digital Estate Kit. So if you navigate to our website and under services and under estate planning tools, you will see the TrueStage Digital Estate Kit. And when you click on that link, you are going to be passed through to TrueStage. And once you get to the landing page, you're going to see a little bit of information. So what the Digital Estate Kit is it's truly designed for very easy, not super complicated legal documentation creation. So this is not for someone that has millions of dollars and, complicated trust situations and lots of properties. This solution is truly for someone who just kind of knows that they want to get some of these legal documents created, but doesn't really know where to start, has some pretty simple assets that they want to protect. And so this is a solution that is really affordable and also extremely easy to use. So what it is a self-service tool. It allows you to create trusts, wills, powers of attorney, different legal documents that you would typically have to go see an attorney to create. As I mentioned, it's very affordable. It's easy to use. It's basically like walking through a website. It'll kind of prompt you to answer different questions. And really what the goal of it is to help families to feel prepared. It's to give peace of mind to your family. To say, you know what, I've already taken the liberty of putting all this information down somewhere that you can access it. You can give this information to your children or to your spouse. And that way, all of this information is accessible. So when you select one of these options, so for example, you can see here on the screen, if I wanted to create a will, it tells me it's about 20 minutes through the process. And it's going to provide you with the last will and testament. You can include a financial power of attorney. You can give some last instructions and wishes that all kind of come with the package. The basic package for this program is an initial fee of $199, and there is a $36 annual fee, not a monthly, annual fee, to continue to have access to the service for a year. So I can tell you with certainty that the cost of going to an attorney's office and making the same request is not going to cost $199. So we've really tried to make this as affordable as possible. There are, of course, more complicated documents that can be created and that would be at a higher cost. But again, this is a very transparent website giving you lots of information about the options that are available. One of the things I really like about this program is that to the left, you can see there is financial education available. And we at the credit union love financial education, as I'm sure you know. Otherwise, you wouldn't be attending this session this evening. But as you can see, there's at the very top, there is a article entitled Understanding Probate. That would be a great one to follow this presentation. Another one below, Bob died without a will. Now what? And again, sometimes, there's just a lot of questions that people have as they are trying to figure out what's next or what do I do to prepare my family? Because it's such a difficult time after the loss of a loved one. The last thing that they want to do is try to start from scratch and have literally no idea. Like, where did my parents have their accounts? Where does my mom do her online banking? Like, what are the different accounts that she has? It's just very stressful to try to figure all that out after the fact in the midst of grieving for a family member. So in the middle of the page, you can see people and institutions. So when you're setting this profile up, you are able to add different family members. You're able to add other relatives that are important. So maybe you have a niece or nephew that you want to include in your will. You can include all of your financial advisors. So how awesome would it be to give your children, your adult children, these are all my financial advisors. These are the people that I work with. This is my insurance agent. This is my advisor that I do my investments with. This is where I have my 401k, or this is where I have my retirement account. That is so helpful to be able to navigate those next steps. As same with institutions, you can see where that person does their banking. So it's a very convenient process. You can give access to your family so they are able to see all of your documents as well as be able to go in and make edits. So let's say, for example, you do create a power of attorney through this process and you decide, I would like to change my successor agent. So, maybe something happened to my spouse and they're no longer able to act. And so I want to appoint somebody else. This documentation allows you to go in, make those changes or amendments that you need, and be able to print it out and have it notarized. I will say all of these documents do require notarization. And if you're a member of the credit union, that is a free service that we offer. Okay, well, I've given you a ton of information. I'm sure you are officially overwhelmed, but hopefully you feel a little bit more prepared as it relates to estate accounts at MSUFCU. But I'm excited to answer any of your questions.
Yes, thank you so much, Laura. And thanks everyone for bearing with us through our technical difficulties. Both me and Laura were both having some issues, but we made it through. So thanks for hanging in there with us. But yes, a couple questions here. So let me get over to my Q&A. Couple comments. Someone said I'm trying to avoid probate with the trust. So yes. And someone else said if I have a trust, this does not apply to me, correct? So
that is correct.
How does that, do you want to kind of touch on that real
Sure, quick? I would love to. So you're absolutely right. A trust is really designed as a separate legal entity. The trust essentially owns all of the assets in which an individual places into the trust. So you would appoint the people that set them up are called grantors, and then the people that act on the behalf of the trust are called trustees. Most of the time, it's the same person or the same individuals. But any money that is involved in the trust, in a trust account, either with the credit union or somewhere else, completely avoids probate. And so the trustees would be required at the death of the grantors to distribute the assets as instructed. So it makes it really easy because it already says, these are the people I want to have my money. And that's basically it. It's very, very simple, cut and dry, and it doesn't require any court involvement.
Thank you. Okay. This one has to do with letters of authority. So if letter of authority means the executor, estate, deceased are the same legally, would executor be able to sign checks made out to the deceased, or do those need to be reissued in the name of the estate?
Nope. So checks that are made payable to the decedent, basically because the decedent and the estate are one and the same legally, they can simply just be deposited into an estate account, or the personal representative can sign the check and they would sign their name, personal representative. And so that, again, is certainly exactly why an estate account is needed, because we do see quite a few checks that come in the name of the decedent alone, or as well to in the name of the estate. So either one of them can be negotiated through an estate account.
Okay, this one's a little, because I think I was trying to summarize it, but I'll just read it word for word. If I have listed individuals to act as my personal representative in my will, would the person who becomes my personal representative, should something happen to me, would they have to complete the letters of authority documentation, or would my will and a death certificate be verification enough that they're going to take action on accounts as my personal representative?
Great question. So that is only so the will is basically a piece of paper until the person passes away and the probate court reviews the will and approves it. So they have to certify that the will is valid before anybody can do anything. So the reason that they certify that is because I'm sure you've all kind of heard like, oh, they changed the will at the last minute. So what they want to do is make sure that to the best of the family's knowledge, there are no additional wills, there were no additional changes that were made, and that the will is not being contested. So that's kind of a sticky situation where maybe two family members disagree about how the will was written or what it says. And so in those cases, the court absolutely has to intervene. And sometimes it requires further arbitration to determine basically what's going to happen. But once the probate court reviews the will, they approve it. Then if they say, okay, you know what, the person this person listed in their will, that looks good. Nobody else is disagreeing. We're going to go ahead and give them letters of authority. But the probate court absolutely has to be involved in that. Once that will has been reviewed and certified, then they will take action.
Okay. The next question, I think it was when you were on the slide about documents and access and showing the application. So the person said, are all of those items used before starting that application? I know on that slide, it also shows like letters of authority.
So we need all of those items that are listed in the requirements in order to open the account. Best case scenario is that we don't open the account until we have everything, because we really want to be able to just move forward with issuing opening the account once those documents and the items are in place. So that would include the letters of authority, the valid letters of authority. We do verify them with the probate court just to make sure that they are valid. We also need an employer identification number from the IRS, and we need a copy of the death certificate. And that's basically it. And the completed application, of course.
That's good. And then does the digital estate kit work in the state of Illinois or any other states for that matter?
Yes. Okay. Yes. The digital estate kit is legally valid in all states. Again, the documents must be executed in front of a notary public to be signed to make sure that they are legally binding and that the person signing is not under duress or is not signing, at the request of someone else. But yes, the documents are all legally binding in all states.
Great. Perfect. And then if you have an estate plan that was created from another institution, can you continue making amendments to it through MSUFCU for the future?
So yes, yes and no, I guess. So like I said, depending on the complexity of what that estate plan looks like, if it's pretty simple, you can basically utilize this kit if you want to go online. You would enter the information and you could begin using the version that MSUFCU has done, but it'll ask you, do you already have documentation? And if so, what does it entail? So it walks you through all of those different things. I will say that there's not like a call center or anything involved with the digital estate kit. So we've had that question come up a couple times, like, is there any resources or any like helpline I can go to? It's really not designed for that. This is really more of a self-service type of situation. And again, that's why the cost is so low. That's why, it's an option. But certainly, if you've got a complex situation or a complex estate plan, we definitely recommend that you seek probate estate types of attorneys that can help navigate those more complicated situations. But what I think a lot of people like, I'm in my 40s. And my husband and I keep saying, "Oh, we're going to put together a will. We're going to put together, a power of attorney or something. If something happened to one of us, and our kids were, left, so we'd want to make sure we have plans in place for that. And life happens. It's like we get busy. Our kids are growing up, and next thing you know, you've never done it. And unfortunately, sometimes the worst happens before you can get to that point. So this is kind of like a bit of a solution that we've come up with to kind of help people say, you know what, this kind of breaks down the barrier of it's too expensive, or I don't want to have to call a lawyer's office, or oh, this feels pretty real. Like, you're kind of recognizing that mortality is a thing. And a lot of people don't want to think about what's going to happen to them or to their family. But honestly, preparation is the best approach. I've been doing this a long, long time, and I can tell you that when family members are prepared, it's so much better for the family that they leave behind. It makes life so much easier.
Yeah, definitely. The next question was just asking how to access that platform. So I did put a link in the chat for everyone. You can click that link and it will bring you right to the True Stage portion of the MSUFCU website. And then you just click there and it will bring you directly to where you can sign up for that if you'd like. Okay. We already answered that one. What if I have beneficiaries on all of my accounts? Do I need a will to say who gets what?
You sure don't, at least not at MSUFCU. Basically, the reason that you would need a will, so a will can be used for a number of different things. A will, in many cases, not only for assets, but it also can be used for tangible items. So, for example, you want to say, I would like my son or daughter to have, my furniture or my book collection or my stamps or, whatever. Anything that you own that's tangible, if you wanted to put in your will, this is to whom I, bequeath, if you will, these objects or this, property. A lot of people also utilize wills for things like, I would nominate this person as my conservator or my representative payee or, whatever the case may be. So they kind of name like, this is a person I trust. This is a person I would want, to act in my stead if I'm not available. And so the will can be utilized in that way. But again, the will is basically a piece of paper until the probate court gets a hold of it and reviews it. And that's really what's going to determine whether a will is formal or informal. So if a formal will takes place, and again, I don't want to get into many of the legalities of this, but essentially the court determining by the size of the assets involved, then they may apply estate taxes. So when we think about like an account at the credit union, for example, and you name a beneficiary, so if I have my account and I said, okay, this is my personal account, my husband's not on it, but I'm going to name him as beneficiary, he just gets the money straight away. Once he gives me a death certificate, we have a quick document that we have beneficiaries sign saying I accept my funds. There's no taxation. So it doesn't go through the probate court. It doesn't go through anybody. It's just an agreement that the credit union made with you as our member. So you can absolutely use your beneficiaries. But what happens is if you don't name a beneficiary on an account, so maybe you say, oh, I'm going to get around to that, and you never did, that's when the probate court would come into play to say, okay, there's nobody that owns this asset now. So there's no joint party, there's no beneficiary. So that's where the estate would claim it and say, okay, these are my funds, or they belong to the estate, and the estate's going to distribute them to the heirs.
Thank you. Okay, next question. I have my sister listed on my checking account with MSUFCU. She's not an MSUFCU member, so must be just a beneficiary on that account. Should something happen to me, would she be able to make payments on my behalf? Would my checking account not be considered part of my estate since her name is also on my account? It's not a
So,
joint account, just beneficiary. Yeah.
okay. So, a beneficiary cannot act on an account at all. So a beneficiary is just in the instance of our member's death. So if they're not a joint party on the account, they cannot do anything. So they would be entitled to the funds remaining in the account. One of the things that sometimes happens is, so let's say that I have an account and I have a loan and my loan has a balance on it and I have enough money in my account to cover the balance. We as a credit union do have something called the right of offset. So we can satisfy the loan balance using money in the account because that's the agreement that all of our loans have associated with them. So if I just have an account just in my name and I have a loan, a credit card, let's say, and I have a $5,000 balance and I have 7,000 in my account, the loan's going to get paid first, and then whatever is left over goes to the beneficiary. But the beneficiary can't touch the account. They can't have information. They can't have statements. All they can have is money. So if you do want somebody to be able to use the account after your death or write checks or whatever, they should be a joint party.
All right. Sounds good. Thank you. Let me just look in the chat because we had some questions coming in there as well. I think you already answered the one about whether the probate is formal or informal.
It
Correct?
depends on the
Okay.
size and complexity of it.
Okay. Yeah. And then someone asked, because they arrived late, if there'd be another presentation. There won't be, but we will be, providing the recording link to all of you as well. So that just takes some time to process that, and then I can send that out to everyone that attended today. So I'll make sure to get that out to you all probably by tomorrow. And then you can always check our YouTube channel. You can just search MSUFCU YouTube and choose the seminar series playlist. And there's just a ton of our recordings there as well. Some of which are, with us on the estate planning topic. And then we also, if this session interested you, you might also want to join us for our lunch and learn if you are in the mid-Michigan area. Laura will be doing a lunch and learn for us. I also put that information in the chat, but Wednesday, August 26th at our headquarters, that will be focused on navigating powers of attorney. So another very important topic that she'll be discussing there. But
We
yes, I will make
also
sure
did
to get those out to you.
we also did one on trust accounts a couple of weeks
Yes.
ago as well. So I have a recorded version of that.
Yep.
So I believe we did that in May or June, I think it was.
Mm-hmm.
And I'm working on some additional recordings and some other upcoming topics as well that we will be navigating in the coming
Yes.
months, if this was of
Perfect.
interest to you.
Yes. Somebody asked about beneficiaries. So updating those. Can you explain a little bit about that on our account?
Absolutely. So we definitely recommend that if you have a beneficiary with us, or if you don't have one, or you don't know if you do, to contact the credit union and ask us. If you do not have one, then we can send you a DocuSign, which is an electronic version of our beneficiary designation form, and we can send it to you electronically. You can fill it out and send it back to us, and we'll get it added to your account. If you have beneficiaries, but you'd like to review who they are, highly recommend that. Many of our members established beneficiaries when they opened their accounts many, many, many years ago, and that may have changed. So if we do find ourselves in a situation where a beneficiary has also died, we would go to the next beneficiary in line, which would be what we call contingent. If there's no contingent, then the funds are the property of the estate. So in that case, a probate estate would need to be required and established. But we definitely recommend it. Also on our website, if you go to our services, there's a list of forms and applications, and the beneficiary designation form can be downloaded, printed off, and signed and mailed. I will say, for beneficiary designations to be valid, we do need to have the document filled out in its entirety, including all Social Security numbers of all beneficiaries. If we get the document back and it doesn't have that, we're going to return it to you. And the reason for that is because we have a lot of accounts where we've got like a junior and a senior situation. So, John Doe Senior, John Doe Junior. and we can't differentiate who those individuals are without more information. So we just made it a of just kind of what we do. And then all parties, so all owners on the account, so joint party, primary party, all have to sign the document for it to be valid because we want to make sure all owners are in agreement with who they are leaving their funds to.
Okay, sounds good. Another one that has to do with beneficiaries here, which the next session on POAs that on powers of attorney that we'll be doing will come in handy. But if I'm a beneficiary on my father's account, will I be able to pay his bills if he's hospitalized, et cetera?
Well, that would be a great time for a power of attorney. So we will, like I said, have a power of attorney session later on this month. But if you do have any questions about powers of attorney, one, attorneys are fantastic resources. But we would definitely recommend that you formalize that documentation. We're not able to accept like informal requests. So like if someone says, well, my dad said it's okay if I sign his checks. Legally, we can't do that. So we need to have the legal documentation. The power of attorney does need to include some things. So really important, it has to have banking powers, meaning that somebody can act on their behalf to do their banking, which obviously for the credit union makes a lot of sense, right? But it also should include the name of the person and the information basically that kind of outlines what they're allowed to do, what they're not allowed to do. We have a form that we ask that all agents sign so that we can identify them when they call us. And the power of attorney basically is valid under a couple different conditions. Most of them are effective immediately upon signing. Some, though, are effective only upon disability or incapacitation. So, depending on your dad's needs, definitely seek some legal advice on what would be good, but please do it before they become incapacitated. So they have to be able to sign legally in order to execute a power of attorney.
Right. Okay, I think that answered all the questions. Yes, our previous recordings are available on our YouTube channel. I just dropped the link to that as well in the chat, so please check those out. But I will send just a link of the Zoom recording to you all directly in the meantime before this presentation gets uploaded there. So where can I find beneficiary information on Computer Line?
Unfortunately, we do not have it on Computer Line because if someone were to access your Computer Line information fraudulently, we would not want someone having that information. So you can give us a call and we can provide you with that information over the phone anytime, or if you come into a branch, we can provide that information to you.
All right, sounds good. Okay, I think that wraps up all of our questions. So when you all close out of the Zoom this evening, you will have just a short survey that pops up with a couple questions to get your feedback on tonight's session. We always love to hear what you think of the topics that we're presenting on and possible topics that you may want to see in the future. So please go ahead and fill that out. And then I just wanted to let everyone know of our upcoming sessions. So we have a virtual session with our FinTech partner Members Mobile, which can, help our members out with possibly a, more affordable phone plan and some other perks just for credit union members. So you can check them out on our website as well in the meantime, if you are interested in that. And then they will be doing an informational presentation to give a little bit more information and answer any questions that anyone may have. So that will be next Tuesday, August 18th at 6 p.m. And then our next two lunch and learns, which we all hope that you can join us for. Thursday, August 20th, will be in our downtown Detroit branch on Congress Street, doing the Computer Line Essentials Lunch and Learn. And then on Wednesday, August 26th, Laura will be back with us at our headquarters to present on the Navigating Powers of Attorney with MSUFCU. So we really hope to see you at another event soon. And everyone have a great night. Thanks, Laura.
Thank you so much, everyone. Have a good evening.
All right.